Hello, my name is Ryan Larimore, and today I will be doing a presentation over legal rights for special education. What to expect in this presentation. This presentation will inform you about educational laws and responsibilities and the impact this will have on my future classroom. Students' rights, parents and guardian rights, teachers' rights, and the 6 components of IDEA. What are some of the things or words that come to mind when you hear special education? Some of the few things that come to my mind is disability, disabled, HAP, mental, medical, challenged, physical, and other words. What is special education? Special education is specially designed instruction to meet the unique needs of an individual recognized as exceptional. Individuals with Disability Education Act. IDEA is Public Law 94-142. It is viewed as the Bill of Rights for children with exceptionalities and their family. It is viewed as one of the most important pieces of federal legislation for children with special needs. It is thought of as the legislative heart of special education. IDEA. IDEA has 6 key components. They are a free, appropriate public education, or FAPE, the least restrictive environment, an individualized education program, or IEP, procedural due process, non-discriminatory assessment, and parental participation. IDEA was signed into law by President Gerald Ford on November 29, 1975. It assured that all handicapped children have available to them a appropriate education, to assure the rights of the handicapped children and their parents or guardians, and to assist state and localities to provide for the education of handicapped children. A free public appropriate education is for all children regardless of the severity of their disability. It is a zero reject philosophy. It must provide education appropriate to the unique needs at no cost to the parents or guardians. Included in this principle is the concept of related services, which requires that children receive occupational therapy as well as other services as necessary in order to benefit from special education. The least restrictive environment, or LRE. Children with disabilities are to be educated to the maximum extent appropriate with students without disabilities. Placement must be consistent with the pupil's educational needs. Individual Education Program, or IEP. This document, developed in conjunction with parents or guardians, is an individually tailored statement describing an educational plan for learners with exceptionalities. The present academic functioning annual goals and accompanying instructional objectives, educational services to be provided, the degree to which the pupil will be able to participate in general education programs, plans for initiating services and length of service delivery, and an annual evaluating procedure specifying object criteria to determine if instructional objectives are being met. Procedural due process. The Act affords parents or guardians several safeguards as it pertains to their child's education. Parents or guardians have the right to confidentiality records, to examine all records, to obtain an independent evaluation, to receive written notification of proposed changes to their child's educational classification or placement, and to impartial hearings whenever disagreements arise regarding educational plans for their son or daughter. The student's parents or guardian have the right to be represented by legal counsel. Non-discriminatory assessment. Prior to placement, a child must be evaluated by a multidisciplinary team in all areas of suspected disability by tests that are not racially, culturally, or linguistically biased. Students are to receive several types of assessments administered by trained personnel. A single evaluation procedure is not permitted for either planning or placement purposes. Parental participation. Public Law 94-142 mandates meaningful parent involvement. Sometimes this law is referred to as the parental law. This legislation requires that parents participate fully in the decision-making process that affects their child's education. Public Law 99-457 is legislation viewed as a downward extension of Public Law 94-142. It mandates service for preschoolers with disabilities ages 3 through 5. It also is permitted an early intervention service for infants and toddlers from birth through age 2 with developmental delays or disabilities. Individualized Family Service Plans, or IFSP, established for infants and toddlers. Developmentally delayed label was created. Public Law 101-476, names of legislation changed to Individuals with Disabilities Education Act, or IDEA. Autism and traumatic brain injury identified as discrete disability categories. Rehabilitation counseling and social work considered related services. It established the requirement of an individualized transition plan, or ITP, by the age of 16 years old. States' immunity from lawsuits for violating IDEA are repealed. Public Law 105-17. Students with disabilities are required to participate in state and district-wide assessments. Transition planning commences at age 14. Orientation and mobility included as related services. Discretionary use of developmentally delayed label for pupils ages through 9 years old. General educators required to participate in individualized education plan team. Students with disabilities are to be involved in and have access to general education curriculum. Public Law 105-17 requires mediation offered as a means of resolving disputes. Benchmark and measurable annual goals are emphasized. Pupils who violate student code of conduct may be removed from their current educational placement only after a due process hearing. Assistive technology needs of each learner must be assessed. Students expelled or suspended from school are still entitled to receive services in accordance with their IEP. A greater variety of assessment tools and strategies are permissible for initial evaluations and re-evaluations. Individuals with Disabilities Education Improvement Act of 2004. President George W. Bush signed this bill, Public Law 108-446, into law on December 3, 2004. Many provisions of this legislation became effective on July 1, 2005. IDEA 2004 will significantly affect the professional lives of both general education teachers and special educators. IDEA 2004 increased focus of special education, improving education performance of students with disabilities. IDEA 2004 modified criteria for identifying students with specific learning disabilities. Schools can now elect a process that determines whether the pupil responds to emphatically validated, scientifically based interventions, commonly called response to intervention. Eliminates the use of short-term objectives in IEPs except for students evaluated the alternate assessments that are aligned with alternate achievement standards. IEPs must include a statement of students' present level of academic achievement and functional performance. Annual goals must be written in measurable terms. It also relaxes the requirements for participation in IEP meetings. Multi-year IEPs are permissible. IEPs to incorporate research-based interventions. Transition planning to begin with first IEP in effect once student reaches age 16. Students with disabilities may be removed to an interim alternative education for up to 45 days for offenses involving weapons, drugs, or inflicting seriously bodily injury. All pupils are required to participate in all state and district-wide assessments, with accommodation for alternate assessments as stipulated in their IEP. Special educators must be highly qualified according to individual state standards. Resolution sessions required prior to a due process complaint. Statute of limitations imposed on parents for filing due process complaints, and modifies provisions of students' native language and preferred mode of communication. While doing some research, I found this comic and thought it would be useful for this presentation. It says, the IEP explains how the LRE is a combination of a SPED in mainstream classrooms with supports from the OT and the PT and SLP, and of course, an EBA and a BIP. Goals of increasing of 5%. Here is a 50-page copy of your rights. Now sign here and here and here and here. The education team, it is important for them to clearly explain with an open, clear communication with the parents so there is a full understanding of what is taking place for their child's education. Student and parental rights include Every Student Succeeds Act, Section 504 of the Rehabilitation Act of 1973, and Public Law 101-336, Americans with Disabilities Act. Every Student Succeeds Act, the ESSA, the aim of the ESSA was to preserve the spirit and intent of No Child Left Behind, while remediating some of the perceived flaws and deficiencies voiced by legislatures, educators, policymakers, school administrators, and parents. This new legislation retains an emphasis on accountability, high standards, and student achievement. The mechanisms for accomplishing these aims is substantially changed. For individuals with disabilities, the legislation ensures access to general education curriculum, accommodations on assessments, and the use of universal design for learning principles, in addition to evidence-based interventions in schools where subgroups consistently underperform. Section 504 of the Rehabilitation Act of 1973. Civil rights laws. Section 504 of this enactment was first public law specifically aimed at protecting children and adults against discrimination due to disabilities. It is said that no individual can be excluded solely because of his or her disability from participating in, benefiting from any program or activity receiving federal financial aid, which includes schools. According to this law, individuals are eligible for services if they have a physical or mental impairment that substantially limits one or more major life activities, have a record of such an impairment, or are regarded as having such an impairment by others. To fulfill the requirements of Section 504, schools must make reasonable accommodations for all pupils with disabilities so that they can participate in education programs provided to other students. Reasonable accommodations might include modifications of general education programs, the assignment of an aide, a behavior management plan, or the provisions of special study areas. Students may also receive related services such as occupational or physical therapy, even if they are not receiving a special education through IDEA. Americans with Disabilities Act, or the ADA. This is considered the most significant civil rights legislation affecting individuals with disabilities. The ADA, or Americans with Disabilities Act, was signed into law on July 26, 1990, by President George H.W. Bush. The ADA goes far beyond traditional thinking of who is disabled and embraces, for instance, people with AIDS or individuals who have successfully completed a substance abuse program, and persons with cosmetic disfigurements. Any person with an impairment that substantially limits a major life activity is covered by this legislation. It extends protection and guarantees of civil rights in such diverse arenas as private sector employment, transportation, telecommunication, public and privately owned accommodations, and other services of local and state government. Public Law 110-325, the American with Disabilities Act Amendment of 2008, became effective on January 1st, 2009. On September 25th, 2008, President George W. Bush signed it into law. This legislation revises the term disability in favor of a broader term. The ADAA expanded the definition of major life activities by including two non-inclusive lists. The first list includes activities not expressly stipulated, such as reading, concentrating, and thinking. The second list includes major bodily functions. For example, functions of the immune system or neurological function. Changes in this legislation also apply to students eligible for protection under Section 504 of Public Law 93-112. The overall effect is to expand the number and range of students eligible under this section. A pupil, however, cannot be regarded as having a disability if his or her disability is minor or transitionary, a duration of 6 months or less. The overall intent of this enactment as ensuring that an individual with disabilities receives the protection and services to which they are legally entitled to. A pre-referral. A pre-referral intervention occurs prior to initiating a referral for possible special education services. The purpose for this strategy is to reduce unwarranted referrals while providing individualized assistance to the students without the benefit of a special education. This strategy is not mandated by IDEA, but has become more popular over the past 2 decades. IDEA permits the use of federal dollars to support these activities. Many states either require or recommend uses of this tactic with suspected individuals of having a disability. Pre-referral interventions are a collaboration between general educators and other professionals for the express purpose of developing creative, alternative instructional and/or management strategies designed to accommodate the particular needs of the learner. This process results in shared responsibility and joint decision-making among general and special educators, related service providers, administrators, and other school personnel, all of whom possess a specific expertise. The pupil's parents typically do not participate this early in the phase. The child's success or failure in school no longer depends exclusively on the pedagogical skills of the general educator. It is now the responsibility of the school-based intervention assistance team. This strategy is beneficial, but is not always successful, but it provides strong justification for the initiation of a formal referral. A referral is the first step toward receiving a special education. A referral may start as a result of unsuccessful pre-referral interventions, or it may be the outcome of Child Find efforts. Child Find is a function of each state mandated by federal law to locate and refer individuals who might require a special education. A referral is a written request to evaluate students to determine whether the child has a disability. A referral begins with a general educator, school administrator, a related service provider, a concerned parent, or another individual. Referrals typically arise from a concern about the child's academic achievement or social or behavioral problems. Referrals may be initiated because of a pupil's cultural or linguistic background, or by the result of problems caused by inappropriate teacher expectations or poor instructional strategies. Only 75% of the referrals for special educations actually result in placement. The remaining children are found ineligible. A referral must contain detailed reasons as to why the request is being made. Teachers must clearly describe the pupil's academic and/or social performance. Documentation may include test scores, checklists, behavioral observation data, and actual samples of the student's work. Information that has been gathered is then reviewed by a committee. Committees vary, but typically include an administrator, school psychologist, and experienced teachers. It is the job of this committee to review the available information and decide whether further assessment is warranted. If the team decides to proceed, a written request for permission to evaluate is sent to the child's parents. School authorities must obtain permission from the parent or guardian before proceeding with a formal evaluation. Assessments. Assessment is the process of gathering information and identifying a student's strengths and needs through a variety of instruments and products. This data is in making a decision. Educational assessments can rightly be thought of as an information gathering and decision-making process. One of the goals of the assessment is to obtain a complete profile of the student's abilities and his or her needs. By law, IDEA, this requires the use of a multidisciplinary team of professionals, of which one member must be a teacher. The team is responsible for developing an individualized and comprehensive assessment package that evaluates broad developmental domains such as cognitive and academic achievement, as well as specific areas of concern noted on the referral, such as social or emotional problems or suspected visual impairments. No one procedure may be used as the sole basis of an evaluation. A multitude of tests is required. IDEA regulations further require the evaluations be presented in the pupil's native language or, when necessary, via other modes of communication such as sign language or Braille for students with sensory impairments. Evaluators attempt to gauge both inter- and intra-individual differences by using both norm and criterion referenced assessments. Norm reference assessments are standardized tests and are linked to individual differences. Data are typically presented in terms of percentile ranks or grade equivalent scores. Criterion referenced assessments are associated with individual differences and can provide data that are useful for instructional planning. Teachers are concerned with the individual's pattern of strengths and needs rather than how the student compares with his or her classmates. My philosophy on special education. My philosophy is to ensure that all students receive and exercise their rights to the fullest extent. It is also to meet the educational needs of each individual student to the best of my ability and help promote students obtain educational goals. This concludes my presentation. I hope I was able to make everybody more aware and understand the legal rights of special education.